Assalamualaikum warahmatullahi wabarakatuh. So today me, Qistina and Meor will be presenting the topic that was given to all of us, which is a hierarchy of the court in Malaysia. So as we all know, we have three different eras when it comes to the courts in Malaysia. The first era is in the pre-1985. The second era we have is in between the 1st of January 1985 until the 23rd of June 1994, while the latest era, which is the third era, is the post-1994 era. So in the first era, we have three different courts from highest to lowest. The Privy Council being the apex of the court, and then we have the Federal Court, which was the Court of Appeal at that moment, and also High Court. For the second era, after the Privy Council was abolished, we have the Supreme Court instead of the Federal Court. The name was renamed into Supreme Court. And then we have the High Court of Malaya and also the High Court of Borneo following up. For the latest era, as we all know, we have the Federal Court as the apex of the court, and then we have the Court of Appeal as well as High Court, Session Court, and also Magistrate Court. So when it comes to discussing the application of the doctrine of stare decisis vertically in Malaysia, we have to go through all three different eras. So let's go to the first era. The first era, we have the Privy Council as the highest court at that particular moment, meaning that vertically the Privy Council, whatever decision that were made in the Privy Council would be binding to other Malaysian lower courts.
Hence, it created two scenarios. The first one being that if the decision was taken in a Malaysian appeal, it will be binding on all Malaysian courts. The second scenario is that where the decision was taken in an appeal from another common law country, and the law in question was similar to Malaysian law. The Court of Appeal in Wong Sileng and Sarawasti Amal in 1954 dismissed the claim that the case was bound to obey its own prior judgment in the case of Yaakob bin Lebay Yusof and Hamisah bin Sa'ad in 1950 because the decision was contrary to the Privy Council decision in Haji Abdul Rahman and Noor and Muhammad Hassan in 1917. However, it has been established in a few cases that decisions are binding on Malaysian courts if the legislative provisions or law in question is in full accordance with the case in Malaysia.
And the High Court would also be bound to follow the decision that was made in the Federal Court at that particular moment. So let's move on to the second era. In the second era, we have the Supreme Court. So the Supreme Court here would bind the other two courts, which is the High Court of Malaya and the High Court of Borneo. It's as simple as that. The thing still goes on, nothing changed. The upper courts would bind the lower courts. So similar to the third era that we are in today.
The decisions of the Federal Court, which is the highest court in Malaysia, are binding on all courts below it. In the same way as the House of Lords of England, now the Supreme Court of the United Kingdom, was not bound by its own decisions, so as the Federal Court. The Federal Court is bound on its own previous decisions only in civil matters, as mentioned in Central Securities Holding Berhad and Harun bin Muhammad Zaid in 1980. That case, but it is actually different for criminal cases. Due to the fact that criminal cases may bring a different showcase of morale and situation, they can dissent from their previous decision if the situation applies.
So since we have three different eras, like I said before, we are going through all these three different eras individually. In the first era, we have the Privy Council, and although vertically it binds the lower court, horizontally it does not bind itself, meaning that the Privy Council is not bound to follow any of its previous decisions. They are allowed to depart from their decisions. Alright, it's as simple as that. For the Federal Court, we have it is bound to civil matters, but it's not bound to criminal matters. Meaning here that it is bound to any previous decision in civil matters, but not bound to any criminal matters of previous decisions. For the High Court, this will remain the same from the first era until the latest era, which is the third era. High Court will not make any precedent. They are not bound to follow each other, and previous decision will not bind any present decision. So for example, we have the case here, Sudralingam and Ramantan Chettiar, which in that case has decided that the High Court would not does not have any precedence in any other present case of High Court. Alright, so for the second era, we have the Supreme Court, we have the High Court of Malaya, High Court of Borneo. So in this case, the Supreme Court is bound by its own precedent. They are bound by their own precedent. But whether the Privy Council from the first era binds the Supreme Court. So the answer is the Privy Council does not bind, and the Supreme Court is not bound to follow the Privy Council's previous decision. But the High Courts in this era is bound to follow the Privy Council. It's as simple as that. Alright, so in the latest era, we have 5 courts here, but we are only going to talk about the Federal Court and also the Court of Appeal. So the Federal Court in this era, I'm going to continue next. So in the third era, we have the Federal Court, we have the Court of Appeal, we have the High Court, Session Court, and also the Magistrate Court.
The decisions of the Federal Court, which is the highest court in Malaysia, are binding on all courts below it. In the same way as the House of Lords of England, now the Supreme Court of the United Kingdom, was not bound by its own decisions, so as the Federal Court. The Federal Court is bound on its own previous decisions only in civil matters, as mentioned in Central Securities Holding Berhad and Harun bin Muhammad Zaid in 1980. That case, but it is actually different for criminal cases. Due to the fact that criminal cases may bring a different showcase of morale and situation, they can dissent from their previous decision if the situation applies.
We have the Court of Appeal, which the same thing, they may depart from its prior decision when the situation falls under one exception, one of the exception, which for example, the prior decision was given per incurium, or there are any conflicting decision, or where the decision is overruled by the Federal Court. Other than that, they are bound to follow their prior decision. That is the case when it comes to the Court of Appeal. So for the High Court, as mentioned before in the first era, they are not bound by their own decision. They never made any precedent. They don't make any precedent.
Based on stare decisis, there is no difference between a High Court judge exercising an appellate jurisdiction and one exercising original jurisdiction. The Privy Council's and Supreme Court's ruling were also binding to the High Court unless they were conflicting with the Federal Court's ruling. The situation was proven in the case of Public Prosecutor and Hua Tian Ning in 2006, whereby the High Court of Shah Alam decided in accordance with the decision of the Privy Council in Public Prosecutor and Yuvarai in 1969. With that, we end our presentation today with Assalamualaikum warahmatullahi wabarakatuh.